So, no, that was my fault. Well, we're not on mute any longer. So welcome back to the Judiciary Committee. We are live, and we're continuing our testimony on a series of bills, H558, 563, 564. And we're going to turn to Sheriff Anderson, who will also need to unmute so he doesn't make the same mistake that I just did. Thank you for being here.
Thank you, Mr. Chair. For the record, my name is Mark Anderson. I'm the Sheriff of Windham County. I am also the president of the Vermont Sheriff's Association. I'm not prepared to represent a position of the Sheriff's Association simply because we haven't been able to come to a final position on any of these three bills. So I'm going to speak as Sheriff of Windham County, and I'm happy to come back for the association if the committee would like. My comments will be brief. I think these bills are either legal or nuance in the essence that I am not skilled. I am not an attorney. So I'm going to speak in layman's terms, and I'm going to speak in common sense, and I'm going to speak to issues that we are dealing with in Windham County and that I have conversed with sheriffs on. With regards to H 558, just a minor grammatical suggestion would be to remove the word aggravated. And the only reason I say that is as we present that word to law enforcement in a training sense, we're probably thinking of that more towards serious offenses, which I would suggest to be a felony. If this is not intended to be a felony, I would not suggest the word aggravated. However, if it is intended to be a felony, then I would suggest reflection on the punitive portion of the bill. Should I pause there and move to the next one, or
go ahead? I got that.
H 563. Is it fair for me to summarize this as attempting to steal a car?
Yes.
I'm not going to share any comments. We're not faced with this, and I know it's an issue in other communities, so I'll leave that for other witnesses or the association to back to it. And then H 564. So this is actually a fairly large issue that we've dealt with in my county. I recognize that there are legal analysis that you've already heard from the Defender General's office. You'll hear from Tim Leader Dumont, and I think I can't speak to that. So I'm going to start with problem statements. Which I think that this bill addresses, but I'm not sure that the language on the page does necessarily solve the problem. Again, I'm not going to comment to the legal side. Problem statement number one is going to be Vermonters or people in Vermont want people to stay out of their car. I think that's a fairly straightforward expectation. And I believe that that is a desire that is currently a gap in Vermont law. I heard the testimony with regards to the Supreme Court opinion, my experience in law enforcement training, as well as my experience in talking with the general public. Law enforcement is not aware that this is a crime. Law enforcement is not enforcing this as a crime. I was not aware personally of State v. Stokes, and I review Supreme Court testimony fairly often. To that end, if there was an assessment that the Supreme Court held that getting in someone's car is a crime, I would still encourage this law because I can point to a law enforcement officer in Title 13 and say, this is the law. Everything we train on law enforcement or train law enforcement officers to do is base their work on something they can point to. If it's a Supreme Court analysis, that's certainly something. But I also know with Supreme Court analysis, they look at very specific fact patterns unless they give us tests that we can use to analyze a circumstance. Again, I'm not familiar with State v. Stokes, but I would ask for clarity that we can help train law enforcement officers on as they receive criminal law instruction from the police academy, as well as we do our annual refresher training. I would also appreciate having clarity in the law to say what is or is not permissible. So coming to problem statement number two, I think the Defender General's office was talking about the inadvertent case. And so what happens if a person goes to get into a black Model 3 Tesla? It's just what I happen to have for a issued vehicle from my department. And they think they're getting into their car and they get into my car. Surely a mistake, an inadvertent mistake. I don't think that that is the intent of this bill, and I don't think any law enforcement officer responding to that type of situation would characterize as anything more than a mistake. That being said, I understand any desire for caution in that sense. And so if there were words that would provide for something that would prevent the inadvertent but allow for the advertent to be addressed, I think that would be helpful for law enforcement. Another issue, you've heard me testify on this on other bills as well. When the case itself takes more time to generate the documents for it to go to court in the court process than it takes for the person to return to the street and start breaking into other cars or entering other cars if they are not damaging the vehicle. It is not uncommon that law enforcement officers are sitting at the office writing the paperwork for the state's attorney, and they're getting or responding back to the same incident in the same area with the same individuals. But I think those can also be addressed in other policies. I mentioned it here. With regards to the co-owners, as I was hearing the testimony, my internal dialogue was that's a civil issue. If it is husband, wife, civil union partner, whatever the circumstance of the legal engagement, I think the point that law enforcement will look at is to say, we don't really know who owns the vehicle, and that is within the jurisdiction of the family or the civil court or the criminal court if they have jurisdiction. And we would not want to weigh into who does and does not have lawful possession without a court order. Finally, with regards to the punishment, or I guess I want to say the resolution that law enforcement will be pursuing through the criminal justice system, I find it difficult to deal with the first offense being a fine only. I would present the question of how are we going to determine if that's a fine only? Is that a fine only issued through the criminal court? Is that a fine that we write a ticket for? It's not clear to me what that is, and there may be someone who can answer that. I'm just, again, not the expert there. I think having a way that we can transact the issue more effectively and efficiently, going back to the law enforcement's responding to these events shortly after they are being addressed, will be helpful. Even if the state's attorney or the judiciary were to consider all the circumstances and say, we are not going to impose a jail sentence, that makes sense on a first offense to me. I'm fine with that, but allowing at least discretion for the judicial system to contemplate some period of time, I would think makes sense. We are seeing these types of issues in Brattleboro. We're seeing these types of issues in communities as small as Halifax. This is, it's happening in my own neighborhood. And so my neighbors are installing cameras and we'll notify each other when the person is walking through the neighborhood and entering a vehicle. This is a fairly common occurrence. I also think it's in some ways on the scale of 1 to 10, this is on the lower end of the spectrum of seriousness, but it's more frequently occurring thing. And so that's where people will then become frustrated that law enforcement isn't doing something. The few comments I have heard from sheriffs, again, I do not have a quorum of a vote, is that we appreciate having more tools to be able to help the community. And so what the policy is of the committee as well as the legislature and how we help resolve and support the community and stop these types of behaviors from happening, I'll trust to the committee, the legislature, and other witnesses to provide those types of things. But those are my comments.
I appreciate that. So we did hear similar testimony regarding the fine only from actually Judge Zone as well. But Angela, you have a question?
That's what I was going to ask about. Thank you so much, Sheriff Anderson. So I know that Judge Zone told us that this would be the first fine only penalty for unlawful trespass. And you're mentioning that as well. So I would love to hear just if you could say a little bit more about that for someone like me who doesn't quite understand why it's helpful to have that. If I'm understanding you correctly, to have the opportunity for state's attorney or even a judge to have the option of imposing jail time.
my opinion to that answer, and I generally don't try to weigh in on what the appropriate jail time is or is not. But that said, my answer to that would be because it gives us alternatives or access to alternative justice programs. So we could say this is I'm going to use DUI, where my county often DUI 1 results in a fine. Not saying that's a hard and fast rule, but that's usually what happens. It also results in accessing the crash program where a person can go receive substance use education as it pertains to driving. So there's options for a rehabilitative aspect. It generally is not going to be a jail time offense, and I would, I guess, ask the Department of Corrections, even if they have any first-time offenses for trespassing currently incarcerated. I think that diversion would be an option. Community justice centers would be an option. It also gives the opportunity for probation to be an option. I don't want to say this as a broad rule. Each of these are their own circumstances, but we do find substance use disorders involved in many of these cases. And so in those cases, having access to, not to say to the criminal justice system's correctional aspect, but some of the substance use treatment programs that the criminal justice system does regularly access would also be a tool. And again, to the point that I already stated, I see this as an opportunity to say this is low on this level of seriousness. Disorderly conduct is low on the level of seriousness, but an incredibly effective tool for behaviors that we want to stop, but we don't want to stop with a very strong hand.
Gotcha. That's super helpful. I did not realize that if it was a fine only, that limited or cut off access to alternative justice options. So that's super helpful. Thank you.
Thank you.
Other questions for Sheriff Anderson? I don't see any. Thank you very much again. And I appreciate it. And we'll probably have you back again on some other thing as well. You seem to be dealing with these issues this session. So appreciate it.
Thank you, Mr. Chair, and thank you, committee.
Thank you.
We'll go to Tim Leaders Dumont, which I understand it might be short, but I'm going to start right out by asking you a question, Tim, if that's okay, since we've already had a state's attorney, Ian Sullivan, go over this with us. But the concept that we were floating around with, if the consent, and I'm looking at 564 in particular. No, I'm not looking at 564. I think I'm looking at 558, actually. Sorry. The without consent. What if the consent was coerced? What if it was a domestic violence situation and the person received consent in some manner, but it was because of coercion? Is that something that would already be covered, or is there a way to actually cover coerced consent that it's without the consent of the owner if it was coerced? Did this question make sense? I don't know if you heard that testimony, but okay, all right.
I understand the question. I kind of want to read, and Tim Leaders Dumont, the Department of State's Attorneys and Sheriffs. I want to research that a little bit more with my off the cuff remark. I'd say that we would potentially, if there were facts that would indicate that type of scenario that you were discussing, which I think is a very good point, I think a lot of people would try. We might even talk with law enforcement about maybe getting a little bit more information about that part of the factual circumstances. So if, for example, the alleged victim said, and also my bank account was cut off, and also my credit card was stopped, and also some things like that, then we would, it could be the type of thing that you would present to, it might result in a trial because, and I would want to look at the case law to see if it's ever sort of been contemplated either in Vermont law or in the Second Circuit district courts, because I think it's a great point. And I could see a jury wrestling with that question about consent. Let's say there was a falling out in the relationship type of thing. I think it's a great question. I can maybe circle back with you on that one a little bit.
No, that sounds good. And we'll also ask, this is new for our legislative council to look into as well. So the other question, I'll stick with 558 and ask a second question. And that is, we're getting a lot of pushback on this consciously ignored language, and looking for another alternative to that, because I think we are still pushing for something that is not the knowingly standard, that high standard. And I suppose we could go to the negligence, criminal negligence standard, but what would that look like as far as what kind of language? I know, I think at one point you may have even proposed some different language, but I just had this language put in there because it's in a separate bill, S58, actually, over in the Senate, dealing with fentanyl and such.
Yep.
What would you suggest?
Two things. The language in S58 concerning the willful blindness, Second Circuit language is about, in the drug context, is about, in the federal courts, is about a person not being able to claim that they didn't know that there was a deadly substance inside of the mixture. And so in this context, I was like, it made sense that you said that. When I'm looking at, there was a case, State v. Day from 1988, that at 150 v. T19, that it says the language of the OOC statute, the language of the statute itself implies that general intent to operate a vehicle without the owner's consent is an element of the crime. The term without consent of the owner implies that the defendant, and here's where we get to the suggestion, knew or should have known that he was operating, in that circumstance, that he was operating the vehicle without the owner's permission. And then it references an earlier case from the 80s. To hold otherwise could lead to unjust results, since a person could reasonably be mistaken to believe they were operating the vehicle with the owner's permission. And now the perfect example is Burlington Airport. No one wants to pay for their car to be at Burlington Airport. And so they always ask friends or family to go in. Everyone has Subarus and Toyotas that look the same. And so sometimes you end up in the wrong car. And I think we all, have got, some people have walked into the wrong Subaru, at the grocery store. So I think it's good to protect against that having too broad a sweep. And in speaking with a couple of states attorneys, they had recommended the knew or should have known language. But I appreciated what you were trying to do with the consciously ignored. The recklessly standard in the jury instruction, which I think someone was mentioning earlier, kind of gets at this, but the state must prove that the defendant acted recklessly. To find that, you have to prove that they consciously ignored a substantial and unjustifiable risk that their conduct would cause the alleged harm. So there's maybe three different ways to go about this. One would be to try the knew or should have known option. The second would be to essentially use that language directly out of the jury instruction for recklessly to place right in here however you see fit. And this option I haven't really thought about too much till just now, but you could say something like the person, and I haven't talked with other people about this yet, but the person recklessly, boom, the rest of the thing, and just say the word reckless in terms of the or in subsection 2 on in the bill for H58. So those are a couple options. But we all agree with you that we've seen cases where I'm going to say the word Joe says they didn't know something, that they were in the car, they're stolen it, et cetera, when, there's video footage of them kind of scoping out the car, kind of figuring out, oh, does it look maybe like it's unlocked? Like the old school cars where you could see the lock was either up or down. And then you just, if it's up, you just go right in. So yeah, I think we agree with the intention of what you're trying to do with this bill for sure.
All right, so we just need to look at recklessly, or, well, what do you think as far as the knew or should have known versus the reckless standard?
That was what was recommended to me by actually State's Attorney Shriver from Windham County when I talked with her about this in the fall. There is, and I wanted to do a little bit more research before I got before you today. There was some unrelated to OOC, so unrelated to the subject of this bill. There is some criticism of the knew or should have known in context where you need the subjective element, like what the actual person was thinking. And I was a more elevated case, right? Like a major felony where there's an act of violence or whatever, the knew or should have known. But here, the knew or should have known kind of makes sense. One, in part because it was brought up, almost 40 years ago in a case from State v. Day that this court basically said that it's implied that the person knew or should have known.
What's the site for that again? I'm sorry, I don't think I caught it when you said it.
Yeah, so it's State v. Day, 150 VT 119. It's a 1988 case.
150 VT 119. Okay, thank you.
Yep.
All right, so why don't we, unless others have questions on H558, I wanted to jump to 564, and I had a couple questions there. Any other questions on the consent, operating with owner's consent? Don't see any. So here's my question on this one is, I think ultimately what we're trying to, I don't know if I'd call it get around, but the issue seems to be the notice requirement as much as anything, that you have to have this actual notice that it's that you don't have consent. Oh, no, wait a second. I want to find where I'm looking. So, the person shall be I'm looking at the unlawful trespass. That without legal authority or the consent of the person in lawful possession, he or she enters or remains on any land or in any place to which notice against trespass is given. So it's that notice against trespass, which seems to be the heart of this issue, that presumably it should be sufficient notice that it's not your car. But apparently this law, as written in the statute, requires there to be actual notice or somebody saying don't go in my car or get out of my car, like the case that we talked about earlier, that I talked about earlier. So we're trying, so is there a way that, rather than, we don't have to have the additional, a person enters the vehicle of another person knowingly they are without legal authority, whatever we're saying there, being in lawful, let's see, that if we just somehow say if it's a vehicle that you don't need to have this other notice provision. I don't know if that's making sense. But I'm trying to figure out what we're trying to get at. But it seems to me that it's mainly the notice issue more than anything else.
Yeah, without the lack of consent is the piece here. You get how to establish that almost as a permissive inference that the vehicle is a place in our society that there's a permissive inference that unless you've received and for example, talking about the airport scenario I discussed.
Right.
In that case, you don't, a person going into a vehicle that's not their own without the intent to assist the owner that they believe is the owner of the car, that you don't want to have, someone, like I said, getting into the wrong car and with no intent to do anything untoward or to drive away the car, getting in trouble for this sort of conduct. But I think providing some sort of, did someone in this committee maybe say in Rutland or somewhere else, people were doing little stickers essentially saying, you do not have permission to go in this car? Was that brought up in here?
Yeah, I think.
Yeah, I didn't bring it up.
But I heard that, but
Chair has mentioned it several
I
times.
don't think you need to. I don't think that's what I want as the answer.
No. It reminds me of like the property cases where in the middle of the North Country of Maine or whatever and they don't want someone to adversely possess their land. They say you're invited to be here because that way it's no longer adverse.
Yeah, right.
But I think here what you're trying to get at is that the vehicle is a piece of personal property, and unless you have the express permission to enter the vehicle, that you're presumed not allowed inside of that vehicle. And I'm trying to figure out how you could get around the notice piece. And I also maybe would like to think about that before suggesting specific language.
Right.
We're definitely in, the same comment that Sheriff Anderson had made about the fine only, as
Yeah.
to the sentence. If it's okay for me to talk about that for one moment.
Yeah, no, please do.
Yeah, so looking at the other property landscape crimes and sentences, for grand larceny, so let's say the car is worth more than $900. I don't know if Jen's still in the room, but let's say the car is worth more than $900. In terms of the landscape of conduct, the grand larceny is a 10-year, penalty and not more than $5,000. For the petty larceny, it's not more than a year or a fine of $1,000. The larceny from a person is not more than 10 years and a fine of not more than $500. And I know all this would be remedied by your classifications bill, but the taking a parcel of realty, some old school language, 10 years, not more than $500. This is one I actually wanted to emphasize: the unauthorized use of a boat or aircraft. Imprison not more than 1 year or fine not more than $500. Maybe that's a starting point instead of, because it has the $500 piece, so that's kind of similar. But it also has the not more than 1 year. I agree with Sheriff Anderson in that engaging the person to show up at court for their arraignment for a fine only for something like this may be hard. And then if we can't get them there, then it's harder, as you were just talking about, Representative Arsenault, to get them into the diversion options, et cetera. And it's also not akin to similar conduct, let's say into a house or into a boat. And the boat example is maybe the most point, or aircraft, sorry, if someone wanted to steal an aircraft. And the last piece is receiving stolen property is to be punished the same way as the actual stealing of the property from the first person. So if someone were to receive the stolen car, for example, like in a narcotic drug transaction, to pay off a debt, then that person receiving it, you would want to ensure that that person receiving it, who may be sort of the head of the snake, so to speak, was not receiving a $500 fine when they were actually the one driving the behavior to go out and steal a car, for example. So just a couple of points, just looking at the property crimes, looking at those sentences to see where your barometer is going to be on this bill. We think the fine only is not something that'll be particularly helpful. Just wanted to mention that.
Yep, I appreciate that. And I think when we have an updated draft of this, it will have I think a 3-month incarceration penalty. That's what we've heard from some individuals and testifying. So,
So Tim, I don't know if you'll know the answer to this, but I'm wondering, in terms of the person receiving the stolen property. So I know for some other robberies, there sort of the precious metals get sold as precious metals. And I'm wondering, I have no idea if that is part of what happens with cars that end up getting sort of junked, so to speak. So yeah. I wonder about, and I've had concerns to make sure that our selling of precious metals laws are in tune with what we're trying to accomplish, so that there's not that direction. So that if that's the path that somebody goes in,
that's what
it's receiving the same kind of scrutiny, because anyway, so that's one thing. Maybe I should just stop there.
Yeah, the catalytic converter can be a very valuable piece of metal.
Right.
So yeah, last year there was did it touch in this committee? I can't remember. There was a whole thing about the catalytic converters. And,
no, it wasn't in here.
Okay, it was transportation. Anyway, a whole thing about basically ensuring what you're talking about is likely to occur down the stream, like the
or chop shop. Right.
Exactly.
Yeah.
Yep. So that was a piece. I forget the name of the act number, but they did focus on that in House and Senate transportation.
So we're able to prosecute. How did that committee not have come here? I don't know. They got towed away.
That's a very good question. I don't.
So I mean, so we might. Yeah, I will be curious to make sure that, because that is a very lucrative field, that we are not letting them off the hook.
Correct. Accountability.
Yes.
Okay. All right. Any other questions, or did you have other points that you could share with us? And I guess we'll be circling back around on trying to get the language right on 564 and on 558. But this helps. It helps me, helps us try to figure this out.
Yeah, the last point was on 563 and speaking
Yeah.
with our state attorneys this morning without doing anything like a formal vote, but I think they're very appreciative of that attempted, piece as well. I think it's definitely an area of concern.
All right. Well, there we have everybody agreeing to one part or one bill. That's kind of like, it was kind of like the work crew that everybody in here at least liked it.
Well, that was my
Kind of like the Twilight Zone.
some of this conduct here would be a really good, particularly the people going into a car and that sort of invasion of privacy, but maybe very, very invasive, but also technically more of a lower level community crime. A great opportunity for a work crew type sentence if someone's exhausted the diversion options. So another good example of a conduct that could be good work crew.
So I think you need to start working, as I've been trying to work on myself, to always say now community restitution, because it sounds better somehow, I think.
I know, but then it may not be as accurate as to what's actually, but no, I agree with you.
But it's in the bill, and what we're calling it is community restitution. So, all right, I appreciate it, and good luck with our friends down the hall.
Yes, no, thank you for letting me do this. It allowed me to, and then I have to go to I'm jetting off immediately afterwards. So thanks. I'm sorry, Vice Chair, that I was not there in person. I know that you prefer
Boy,
that.
I'm taking a beating for that today, aren't I?
All right, thanks a lot, Tim.
Thank you all. Bye.
All right, Chief, finally, and thank you for your patience, Chief. Here. Mainly, we had you go last because I knew we'd be able to keep Ken here in the committee room if we had you go last. So if you could identify yourself for the record, and if you could give us some comments on these bills.
Yes, of
I know you
course.
provided some information.
I did. I sent a PowerPoint along with some images to talk about the scope of this issue.
Did you want to share? Or you don't have a screen to share it on? But
No, I don't.
I can try sharing.
Yes, that'd be wonderful if you could.
so yeah, why don't we get that on, because it's I think that it's pretty interesting. Exactly.
My name is John Murad. I am the Chief of Police in Burlington, Vermont, and I am incredibly grateful for the invitation. I actually haven't had a lot of opportunity to come down to the State House since I've been acting and now Chief of Police. But coming down here reminds me of, my school trip when I was at Underhill Elementary, Underhill Central. I think it has. I mean, I did come down once back when I first started as a deputy chief, but it was not for a formal occasion. And so this is wonderful. And walking and seeing the State House again, you guys have a wonderful job, a really important job, and one that I'm sure the grandeur of it actually sort of escapes you on a day-to-day basis, just because that's how life is. But it's an amazing place.
Have you been with Burlington? I know you haven't been chief that long up there, but how long have you been with Burlington?
I was born in Burlington. My parents were professors at the University of Vermont for very many years. I grew up out in Underhill and was a graduate of Mount Mansfield. I went away for college. I became an NYPD cop. I returned to Burlington in October of 2018 as the deputy chief of police, and then became the acting chief of police after the chief of police who preceded me had some issues, and then it was sort of off to the races from there.
Yeah.
So that's my short history. Anyway, these are terrific, I think, bills, and I am eager to talk about all of them, but I thought we might take a look quickly at the scale of the problem that we're seeing, at least in Burlington. So if the next slide, thank you. So this is a picture of our stolen vehicle incidents. These are not the same as offenses. These are incidents reported to the police. And what you'll see there is that, from 2018 through 2021, we had a phenomenon that was relatively within bounds, down in the very low, below 50 most of the time, And it has absolutely taken off in the most incredible, crazy way, starting in 2021 and then through 2022 and 2023. 2023 was slightly better than 2022, but not by much. And that is just completely out of keeping. Next, please.
These are only the ones that are reported?
That is what is reported to the police. That is correct. Stolen vehicles reported.
Any estimates on how many there is actually? I mean,
I think there are probably quite a few that are not reported. I think with vehicles, however, people tend to report. When you walk out and your car is gone, it's one thing not to report a small theft. It's one thing not to report, vandalism or something that you really think they're just not going to come. Petty larceny from a store, retail theft, we absolutely are underreported on those, but people report it when their car is taken. This is where it occurs. Next, please.
And
Sorry.
I'm sorry. So I'm wondering, the ones that are on that chart, are those confirmed stolen? I know, I think you and I have talked about the towing issue. I know that people have told me they've called the police a lot because they think their car was stolen, but it was towed.
Yes.
So I'm wondering if those, if it turns out that it was towed, if that,
Those get knocked out.
those get, okay,
Yes.
great.
So stolen vehicles that are not stolen because they were towed or because, we have some residents sometimes who forget where they put their cars. We have out-of-towners who forget which garage it's in, and they go back to the Cherry Street garage instead of the Marketplace garage and say, oh my goodness, it's stolen. Those, once sorted out, are recategorized, so they would not be captured in that. Next, please.
One second.
Sure.
The heavy area, is that
That's my
downtown?
house.
That is downtown. So yes, this is downtown Burlington, bounded by Main Street and Pearl Street. So that is the area of we have the parking garages in there. We also have just areas on the streets and the side streets, and this is where people steal because this is where people who currently need to steal take it most often. And we do not see car theft that is driven by economics. That is in the sense of selling the car. Let me clarify. I do believe that people's economic condition probably drives them to steal, but they're not selling these cars to ship them up to Montreal to be chopped and or shipped overseas. They are stealing these cars as conveyance and or as a place to stay, and they are using them until they are used up. And sometimes they use the cars until they run out of gas, and the people have so little money that they can't afford to refill the car. And why would you refill someone else's car? And you leave it and abandon it. But it is often left in a condition that is really just something that's unacceptable to the person who reclaims it.
So we'll go back to what I said before. There is a lot of squatters that are using these cars?
Yes, a fair number. And it ranges from people who are squatting in it and living in a way that is completely hand to mouth and they use it up immediately. Or, we had a car from a prominent member of our community. It was stolen at the airport, as the state's attorney mentioned. It was stolen at the airport, and then it was recovered months later and had been being used with the same plates and everything, just by someone else. He'd in the meantime, the owner had in the meantime had his car replaced by his insurer, and when it was recovered, he didn't want it back. But in that instance, the person did keep filling it up and using it. So that's what oftentimes we see. We do not see a lot of car theft for value of the car. We also did see a spate over the summer of car theft that involved juveniles who were stealing cars based on a trick that can be learned online, used mainly with Kias and Hyundais. You can break open the steering column and basically insert a USB cable and start the car. You're hot wiring it with a USB. And those youths generally stole the car intentionally to race it till it was destroyed. And they would just drive it incredibly hard and run it into things and then run and abandon it. And because they are all juveniles, it was very difficult to address those children. One of them was involved in the homicide in Bristol, that made, obviously created a lot of community consternation. But next.
So Tom had a question.
Sure. I'm sorry.
Just to expand on this, you're headed down the right track. Are most of them taken by convenience? It's left running outside somewhere, or are they looking for keys or a little bit of both?
With the absence of that subset of the Kia Hyundai, and they actually called themselves, some of them, the Kia boys, but with the absence, the exception of that subset, yes, these are targets of opportunity. We do not have sophisticated car thieves who can jimmy into a door, hotwire the vehicle, and take off in it. We have people who are taking advantage of the fact that, we used to have 30 car thefts a year in Burlington, and when you only have 30 in a city of 45,000, people can leave their cars unlocked, and they do. And they leave their car running, and they do. And they're still doing it even 3 years into this incredibly large uptick, and they are being sort of punished for it in the sense that, you come out from the corner market and your car's gone. These are larcenies from the motor vehicle and offenses. Now, these are not calls for service. These are actually offenses that we arrested or recorded as actually having happened, not just a call from the public. And here too, you can see just a tremendous uptick in the 2022, 2023 years. Next, please.
Angela.
A question about
Sure.
that. Recognizing you may or may not have this off the top of your head, but do you have a sense of, out of that number, say the 917, 946, how many of those, sorry, let me back up. These are things being stolen from a car.
Correct. This is larceny from a motor vehicle.
So how many of those offenses were involved firearms?
I would not know the exact number, but not an inconsequential, inconsequential number. There were certainly instances. We've had just recently a man who has been plaguing the downtown garages where the hotels are on Battery Street, Cherry Street, and College Street and Bank, excuse me. Was arrested in early December for having stolen 2 rifles out of a car. So we are seeing that. That is something that may not be reported as often. I think there are people who don't report the loss of firearms. I think there are those who are concerned. I think there are those who might have concerns that reporting the loss of a firearm invites a certain amount of government intrusion into their firearms, and they don't do it. But I do think that what this also includes is people arrested in stolen cars for whom we cannot prosecute them or charge them with the stolen car, but we can charge them with the stolen property from a car. So, for example, I take you out of a car, you claim that you were given this car by somebody else, and I cannot disprove that because your friend Kim gave you the car, not you. There is a memo from our state's attorney that says that that is not in and of itself an unreasonable defense. And therefore, I can no longer make the charge for the operating without owner's consent, but I can charge you for the debit cards that are in your pocket that belong to the person who owns the car. So some of these are going to be things like that. Next. These are all trespasses, not into a vehicle, because the Defender General's opinion notwithstanding, I have never, and I do not know of anyone ever having prosecuted or charged rather trespass for a vehicle. It's just not something that we do. And in fact, as I said, we do have a memo from the Chittenden County State's Attorney that states quite explicitly, the fact that the fact that they are operating or using the car and it is stolen is not a crime. That's the stat. That is that alone.
Say that again. Yeah.
The fact that they are operating or using the car and it is stolen is not a crime. We are required to demonstrate that the person knew the car was stolen or stole the car him or herself, which would obviously mean that they knew it was stolen. Being in the car, using the car, and being reported stolen is not a crime. That is a memo.
And Ken was driving it. He didn't know.
Correct. Okay. So Ken took it from you and you told him it was your car, and Ken is acting in good faith, right? And that is not implausible. However, when Ken tells me that he only knows your first name and it's not actually a name, it's your street name, he just knows that you're Dandy and that Dandy gave me the car. Dandy's never had a car. Dandy doesn't actually live in a house. Dandy has been staying in Sears Lane in the encampment, and Dandy gave me this $55,000 car. That should be in and of itself a presumption. It is not currently. Now, if we had a trespass offense, then we could say that that was part of it. But I'll get to the specific bills in a moment. Next, please. I think this is the last one.
So before,
Oh, I'm sorry.
On that situation, even if Tom were driving, if Dandy is driving the car, you can't, even though you can't arrest him, you can't say, this is a stolen car, so I will be keeping the car.
Oh, I keep the car.
Okay.
I absolutely keep the car. It is a stolen car and you don't get to drive away in the car. Neither would you. But Dandy is going to tell me the same thing. He's going to say, I didn't take this car. Now, if I have proof that I have video of it, I have a witness of it, that's a different story.
Right. Okay.
And that will absolutely be accepted as charges and prosecuted by our state's attorney or any state's attorney. It's that distance in between the two.
And you can't bring him down to the station and question him?
I don't have any, I can if there are other things. Now, he may very well have warrants. And again, with the scope of this problem, and the reason I showed these graphs first is because the scope of this problem is not people accidentally getting into the wrong Subaru in the Hannaford parking lot. This is not people in good faith taking a car off the top deck at the Burlington International Airport parking garage and driving it home and having it, golly, that could happen. That car could be gone for a week, sitting in an unknown driveway in South Burlington. And when the people get home from their trip, they go, that's not my car. Hey, Peter, you just took the wrong car. And Peter goes, oh gosh, I took the wrong car. And they quickly report it. They tell the police and the police say, oh, and everybody laughs. Peter's not getting arrested. And the people who had that car are not getting arrested. That is a distraction from what the problem actually is. The problem actually is that we have huge numbers of folks who, for a variety of reasons, this incredible combination of punches that we took with regard to political upheaval and a global pandemic and which caused a court shutdown, which I think is probably our biggest issue, which then led to a change in the drug picture, a change in the number of people suffering from substance use disorder, incredible amounts of despair, houselessness, and then the second biggest issue after the court closure, a drastic withdrawal by police owing to what happened in 2020. In my agency's case, a physical withdrawal in that there are fewer of us by 50%. But in other agencies' cases, the fact that there's not a cop in the country that kept policing the same way in August of 2020 as he or she might have been policing in May of 2020. Not a single one. Every single one of them was more hands-off, for good and for ill. And the ill is that we have people who know that this is the case, and they are acting with impunity because of it. That is what is driving those massive upticks that we see in these kinds of crimes. It is not people who are getting in the wrong car at Hannaford. So
just want to make sure I'm following all this. There's no way somebody is taking a car from doing somebody a favor, picking up a car from the airport, taking it to somebody's house for a week. They don't have the key that's going to match that car. They don't have a fob. They don't have anything.
Well, they do have the key because, for example, even in that prominent Burlingtonian whose car was stolen from the airport, it's because the key was left under the mat, and that is something that happens at the airport. Hopefully,
the car unlocked.
They leave it unlocked with a key because I needed to fly out at 3 a.m. But I don't want to pay for a week of parking at the Burlington International Airport. So my neighbor and his wife come by and they see the car, and the neighbor, she gets out of the passenger seat and the other neighbor stays in. He says, see you later, honey, I'm going to work. And she says, thanks, I'm taking this back to the neighbor's house. She gets in the car. There's a key right under the mat like he was told, gets in, drives it back to the house in South Burlington, leaves it in the neighbor's parking garage or in the parking lot or the driveway rather, and then does her own thing for a whole week.
That happens?
So, no, it certainly can happen.
Until I heard about this.
It absolutely could happen. And has it happened? I wouldn't be surprised. Not that I have ever recorded or known, but that seemed to be the kind of case that was being envisioned by both the Defender General and by the state's attorney with regard to sort of why we should be cautious about these kinds of rules. And I don't disagree with that, but I do disagree that that is anything close to the cause of where we are with regard to this phenomenon.
I mean, that's really going out on the limb.
Well, right, and you're bringing in the fact, of course, that that law enforcement officers have discretion, and you have common
Yes.
sense, and you would take
Yes.
everything into account and understand the situation. And
Absolutely. And what I would say in talking about the bills in general is that the big thing that I think that Vermont could use with regard to these is that presence in or operation of a stolen vehicle for a person, caught operating or using a stolen vehicle, it shall be an affirmative defense that the person did not know it was stolen. And that places the burden back on the individual. And I wish that I hadn't gone last, because I wish that you would have been able to bring that concept up to the state's attorney. It shall be an affirmative defense that the person did not know the car was stolen. That puts the burden, and suddenly saying that it was my friend Dandy, whose last name I don't know and street name, that it is going to be much more difficult for that individual to make that case. And he's not making it to the police in the field. He is making it in court to someone who's going to be able to actually see through that. And you need to produce Dandy, and you need to actually demonstrate all these pieces. With our hypothetical about the good-natured neighbor who took the friend's car home, that is all easy to do. And in fact, it will never even get to court. But with a case in which Dandy really, which when we have a person who really was an unwitting dupe of a ill-intentioned friend who, took the car and perhaps should have known better, that is where we will be able to actually have some kind of action. And I think that would be an important tweak to both both 558 and 563.
Barbara, go ahead.
So Dandy needs to show you his license, right? Does Dandy,
If he's operating it.
does Dandy have a license most of the time when you're stopping? Like,
Sure.
I'm just wondering.
Sometimes no, sometimes it's suspended. And in that case, we might arrest the person for that. But it's the possession of the car and
Sure,
that
right.
that we're concerned about. And in my original hypothetical, of course, Dandy wasn't even there because Dandy's not real.
Yeah, okay.
Is the point, is the person is saying, my
Right,
friend.
yeah. Whoever's driving, like, I'm just trying to figure out, like.
Yes. Whomever is driving is going to be everything that we can do short of accusing that person or arresting that person for the car theft.
Right.
We are doing.
I guess I was trying to figure out like how big a net, like how many people who are driving a stolen car have a valid driver's license and how many, like.
I don't know. That's an
Yeah.
interesting thing. I could try to dig into our, and see if there's a cross reference of, I could ask our data analyst to cross reference whether or not those arrests are being made with or without, DLS charges as well.
Is that what you're looking for? Is it DLS?
No, but I guess I'm just trying to figure out like, how many people are you saying, oh man, I know something is, like, how often are we just.
Having to let them go?
Right, and then you have no way to contact.
Quite frequently. So you've seen the number of offenses that there are, of reported crimes and of offenses. In 2022 and 2023, with all of those multiple offenses, we made 96 arrests for operating without an owner consent. And that was for 67 people. So we know that there are many people that are doing it again and again repeatedly. I have one gentleman here, six offenses in that 2-year period for the same crime. They're not being held. And that is why I say that the court closure and the backlogs that it has created are by far the most significant piece of this very myriadly, this multifaceted problem. But it is also the challenge of saying that those are only the times we were able to hold him accountable. I'm quite confident that if I looked into that person's total Valcor engagements, there are also going to be many instances in which he is called a person of interest with regard to a stolen car rather than the arrestee.
So if we look back at your chart and we looked at when the court backlog started, that's exactly when the numbers started jumping, right?
So if we go back to that first, I'm sorry, you don't have to pull it up again, but if we go back to that first slide, the first slide, yes, in 2021, that's when the closures really start to sort of take effect.
Yeah.
And then the issuance, I have a circle here, you may or may not be able to see it, but that's the issuance of the memo from the state's attorney's office, which is when in 2022, the numbers really started to take off. It was quite clear that we were putting absolutely unprecedented numbers of cases of this type to the office.
So before lockdown, well, I'm also thinking back, 96 arrests for 67 people. So I'm just wondering, like, people were going to court pretty quickly and getting dealt with. So it's hard to know, like, would this bill make a difference? Like, how much of it is like we should get the courts to be back to that stage so that it's happening? And how much is this bill? Like, if we did this bill and not the court backlog, where would we be?
Well, I certainly don't think that they're mutually exclusive by any means.
Sure.
If one were to happen without the other, I think fixing the court backlog would have the bigger impact, period. It would have the biggest impact on everything that has to do with the criminal justice system at the moment. There are just too many cases that we are not pushing forward in a timely way because of that backlog.
Right.
And I feel it too in my own world. I have a tremendous backlog of online reports for retail theft because in the same way that the court was closed and could not keep up with its workload, with fewer officers than ever before, I could not keep up with our workload. We pushed a lot of reports online. It was a mistake because online they just disappear. And they just get into this stack over on the corner of my mind, out of sight, out of mind, that just keeps getting bigger until suddenly we turn and we go, holy moly, where did that come from? Whereas at least when calls come in, and even if we have to do what we call stacking them, which is that we cannot respond in person in a timely fashion because of resources, at least that stays right in front of us on our computer board as an unanswered call that somebody has to get to in the next couple hours, couple days at most. Those onlines just disappeared. And the same is true, particularly for minor kinds of cases in the court system. They just stacked up and nobody even cared. Nobody lost sight of the murders. Everybody was still working on those, preparing for when the court would open again and we could finally get at this murder or that murder, of course. But the little stuff, it absolutely stacked. And it's to everybody's detriment. I'm sorry.
Oh, that's good.
So just to back up, because I'm constantly hearing about this court back, which, okay, it's there, right? I'm constantly hearing we got 10, 20, 30 cases, dockets, whatever you want to say, of these same people over and over that you guys put your lives on the line all the time for. You arrest them, they go to court, and they're released. And you want to talk about a backlog, look at how much time we're wasting there. We got to have a sheriff or you or whoever go down there and do all that stuff. It's taking up the court's time. It's taking up the lawyers' times, which we don't hear. We don't have enough lawyers. We don't have enough judges. The only thing we have too many of is too many legislators. Whoops, I didn't say that. So anyway,
Waiting for that.
the point of the matter is, oh, you know what's coming. So anyway, again, back on point. The backlogs. But we keep arresting the same old people over because we're not enforcing the laws.
We're certainly trying to enforce them. I think what we're not seeing is adequate or timely conclusions to those cases. I think generally, so there's a 3,000 plus case backlog in Chittenden County, and that is extraordinarily difficult for the Chittenden County State's Attorney's Office to address. I think that when as far as I know, and certainly a member of that office would be a better person to answer this than I, but when the same person is arrested again, certainly for a similar offense, that case is rolled into one of those existing cases. So that doesn't create an additional backlog for the most part. Those cases are all what's stacked up over the course of basically 3+ years of both absolute inaction and then much slower action than normal. But I really am not the best person to speak to about, like, that would be better for a member of the State's Attorney's Office to talk about how all that works.
If it's the same type of crime that they're doing, it's probably in the same docket. If it's the same person doing a different type of crime, it's into a different.
I'm not entirely, I don't believe so. I think it depends on the severity. I think sometimes certain like repetitive trespass arrests tend to get rolled into a single case. And some of them are then dispensed with without prejudice, saying that we're not going to deal with these because we have a whole bunch of these already. I'll keep taking the cases as they come in, but I'm not going to actually put them in front of anybody. But that too, I really urge that be answered by the State's Attorney's Office and not by me.
Thank you, sir.
So a couple things, the state's attorney's memo that you mentioned regarding auto theft, can you get that to?
Absolutely.
Put that online as well. So I want to actually go back a little bit and very basic for me is, so when do you use grand larceny Title 13, 2501, as opposed to 23 VSA 1094, the operation without consent of owner? Can you kind of just go through how you deal with people and wrongdoing with autos?
Sure. Thanks for that question. We almost exclusively use the operating without an owner's consent. It is almost always the Title 23 charge. And that's simply because grand larceny, they're relatively the same if the two are present. And using grand larceny for a vehicle without a specific statute for a vehicle just isn't done very often. And that's why I think it's important that there be a statute, additional language adding something to the larceny statute for auto. And I think New York State very explicitly has, it carves out an exception for vehicles. It says if the value exceeds $100. So in other words, as it outlines what grand larceny is, it has a subset of grand larceny for automobiles, and it says exceeds $100, which gets at what Ms. Pullman was talking about with regard to, how much is a vehicle worth? If it operates and it's mine, it's good enough, but it may not be 900 on the Kelly Blue Book. And so I certainly am not saying that is something that you do for other. That's a different argument about whether that changes for overall larcenies. But for an added statute about cars, you just say, look, if it's a car and it's worth more than $100, which just about any car is, then it's grand larceny. And a component of that is an understanding, as she pointed out, that cars are unique to us in being a necessity for modern life in a state like Vermont, where we are relatively far flung.
All right.
So, okay, so if a car, do you end up adding the contents of what's in the car to?
No, we generally would do those. We might do those separately. Particularly, we might add, for example, an identity theft charge if the car had credit cards or things that allow us to make that charge. If there were, in the case of, for example, the Christmas, we had a woman who stole a car on Christmas Eve, and we could not. We did charge her ultimately after doing some legwork and video work to find out that she had actually taken the car. But initially we couldn't hold her on that, even though we found her at the car. But we were able to hold her on the things that were in her constructive possession, which included the stolen Christmas presents from the back seat. And so that's going to be a separate charge within the same arrest.
So if somebody,
but we don't add it up to the value. Like the car is the car.
So one charge is the car, then the other charge is, right, because we had heard from some people that there are cars on the cross streets of Church Street and people take, the 10 North Face jackets and put them in the car. So if you're stopping that person, you're charging the 10 North Face jackets at your own.
Correct. We'll start either grand larceny or retail theft for those. Yeah.
But man, just to go a little deeper, if somebody steals a car and there's a lot of personal contents in there that's worth a lot of over $900, they're going to be charged with a larceny charge too, correct? The stolen car plus the contents?
They could, if the contents were specific enough to sort of demonstrate their specificity. I just used the same word. There's a tautological definition. If the contents were sufficiently specific that we could differentiate them and say there was also $10,000 in the back seat in a duffel bag, and there was also, that might raise my eyebrows, but there was also this thing. There was an Xbox in a box. There was a computer. There was a laptop. Yes, we would add that. We might add that to the operating without owner's consent. If the person were found in possession of all those things. But we don't always. It's sometimes just getting the car and all those things back is what's important. We definitely do if those things are from a different car larceny or different larceny, because that's often what happens. What you were sort of showing is that the person didn't have 10 North Face jackets in their back. It's just that was what I grabbed the 10 North Face jackets and ran to the car that I'm stealing or that I've already stolen to make my getaway with those jackets. And we definitely would charge both of those. But we don't very often say, I recovered your car and I recovered your laptop, so I'm giving the person a charge for the operating without an owner's consent and for a grand larceny for your $1,200 MacBook. We don't do that very often.
Angela.
Can I ask you about those circumstances, or maybe give us an example of where you wouldn't be able to charge someone with much of anything? And so I'm thinking of 564 and this idea that you cannot be charged with a crime simply for entering someone's vehicle, maybe rifling around. If you don't take anything, you find anything of interest.
Yeah.
What Jennifer Pullman explained happened to her son's car.
Yeah, that's
a gap.
We would not really be able to make a charge on that. We might try to make some kind of vandalism charge depending on the damage to the car. But if it's not substantive damage, but is instead just sort of, it was trashed, to use her words, that's going to be challenging. If they didn't break things in the car, if they didn't slice up the carpeting, if they stole something from the car, that's different. We have all those, larceny from a motor vehicle. We definitely charge that a lot. If they've destroyed the car, done something to it, that would be, although even there, it would probably have to be an overt act of destruction. Merely, defecating in the car, which people have done, or using drugs in the car that then create messes of all sorts of fluids, which many people have done. That alone might not be something we would necessarily charge. I'll have to look in to see if we have, but I don't off the top of my head think that that's something that we've added. The trespass would be tremendously helpful because the trespass does give us the ability to address a person who, you round the corner and there in the sort of darkish alley is somebody's rear sticking out of the car, the open car door, and they're going through it. That's a charge now. I don't currently have a charge for that. I currently have a, hey, what are you doing? If I watch a little bit and sort of get the sense that that's not somebody looking for the key that fell out of their pocket while they were driving. That's somebody like rifling through this car. What are you doing? And then if I have to call the owner, I have to determine whether or not anything was taken. I pat the person down. Does the person have anything on their person that might have come from that car? If the answer to all those things is no, then it's mostly a be on your way.
And is that something that your officers encounter?
Yes.
A lot?
Yes, absolutely. Yeah. And also, unfortunately, more often they're actually in the car driving it and we recover it. But the trespass would at least give us that as well. And again, the affirmative defense would also be tremendously helpful. But even without that, which may be a hurdle too high, the notion of saying, look, just being in the car is good. There too, the person is going to say, well, I'm not trespassing because it was given to me by who? By friend. We need a structure by which that is not what is absurd on its face to a reasonable person is also absurd in the law. We need that, and we don't currently have that.
So I have another question. Jennifer talked about the towing, the car gets abandoned.
Yeah.
Especially when it runs out of gas, I know, or
Yeah.
when whatever. Is there anything that we can do to have the towing company run obviously if the plates are on it still and it's reported as stolen, or the serial number, so that the owner could be contacted and there aren't, because somehow that.
Rather than the tow company?
Well, just because it sounds like by the time the owner finds out, storage,
Mhm.
it's not $1,000 for the tow.
Right.
So I'm just wondering how to try to not have the insult to the injury
Yeah.
be as big an insult.
That's a great question. I don't know that there's an answer to that. They do run it. They're required to run the VIN number and their license plates, and then report it to us on a daily basis. So it's never supposed to sit there that long if it is reported stolen. If it's been reported stolen, it's something that we're supposed to be able to catch relatively quickly. Asking the tow company to do it at the scene before they even tow is going to go against their sort of profit motive is my guess, but you could create something like that.
Well, I'm just wondering if they then are also touching a vehicle that is still, they're not entering it necessarily. Well, maybe they are because it's been left in that condition.
Yeah.
But they're in that chain. So in a way.
That's a good question. And I don't know if maybe they don't really enter it for the most part. They just, they hook it up and tow it. They don't go inside it.
That's not the towing, the towing company is not the law. That's not their job. They tow cars.
No, but if they need to notify the police quickly, right?
Well, they don't do it. I mean, they do it on a sort of, they generally on a nightly basis.
So, but people, I don't know if you've had constituents have this, but, and you've seen some of the data from justice.
Yeah. If a car gets abandoned by the people who stole it and it then gets flagged as abandoned, we'll look at it. We'll say, yeah, either that is stolen or maybe we don't know it's stolen, but tow it, and we call a towing company and the towing company comes and gets it. Or you might do so if somebody leaves a car in front of your driveway and you call and you say, there's a car in front of my driveway, and the towing company comes, takes it. And then when they take it back to the lot, they record information from it. And sometime in the 24-hour period, I believe, I could confirm this definitely with one of my officers, but they're required to run those numbers or send it to us to run.
Right.
Then we check and we say, yeah, these are stolen or not.
Right. I guess I'm not sure why they're getting $1,000 bills, but people have been like.
Actually, don't go to us anymore. They go to parking. It used to come to us when parking was part of the BPD, but it goes to parking now, and parking runs it. And so that's why, I was, because I used to get those every morning. Every morning I would get a list of everything that had been towed in the city and, whether any were flagged. And I haven't in quite some time. And I'm suddenly realizing that's because parking was moved out to DPW in 2020. But they do. That's one of the first things the parking folks do. They run all those things from overnight and they say, yeah, this one was stolen.
Yeah, I just know like some of the victim advocates have been like, can't you do something about that? And
I'm certain that your car's stolen and then you also end up with a fee. Yeah, that's terrible.
That the insurance company won't pay.
Yep. Yeah.
Good comments and see about the insurance.
I will.
So I think I understand that it's been very helpful to us to understand the holes that the gaps that we're trying to fill. Whether we fill it with an affirmative defense, I'm going to talk to some folks about that. This has really been a focus of trying to get that right, the mens rea right.
Yeah.
If it's an affirmative defense, but we know the gaps we're trying to fill, and we'll figure that part out.
Yeah.
So,
I think that there's the language for the reckless standard is consciously disregards a substantial risk that the material element exists. And so in this case, it would be, you're consciously disregarding a substantial risk. You're making a choice that the risk that this car is stolen is not a high one, right? And we need to put that burden back on the people who are in the car so that they cannot give us an absurd on its face response to, where'd you get this car? From the friend I don't know, whose name I don't know, at a time I don't remember, and it's not mine, man. And that is something that, we see all the time. I've been told that by people that the pants they're wearing aren't their pants. It's just something that people say. But in normal situations, we're allowed to say, I'm not accepting that. That's unreasonable. I still record it. It's on my camera, but I'm not taking that as a reason not to arrest you. These aren't my pants, the pants that had lots of crack and a gun in it. Okay, you're still coming in with me. But when they say that about the car, this is not my car and I got it from my friend, we have to let them go. And that we need something to fix that.
Right. Yeah, and I'm not sure that necessarily the affirmative defense. I mean, there's different ways to get there. And the affirmative defense, eventually, if it's in trial, the state's attorneys have to disprove the affirmative offense if it's brought up. So it may be 6 of one, half dozen of another, but I think we're after the same thing.
Yes. Although actually, I think the difference with the affirmative is that it puts the burden of proof on the accused, not the prosecutor.
No, eventually, no. I had this question and I pushed the prosecutors, I think it was last year, on this, trying to understand who had the ultimate burden of proof on an affirmative defense. And ultimately, the prosecutor has to disprove the affirmative defense if it's raised. There's like maybe there's a threshold burden that the defendant has. I will ask that again.
Yeah.
I'll ask that again, but that's because that's I didn't really understand that was the case until really pressing that on another law.
Interesting. If that inadvertently makes the burden of the prosecutor greater, that is not what I intended by offering that as a suggestion.
So it may be better to have a should have known type standard.
Yeah.
Or reckless. So Ken, you have
It just absolutely blows my mind that some of this wasn't already a law way before now when we're dealing with these 3 laws. It just.
I think if you do look at that chart, vehicle theft stolen vehicle as a report was not something we dealt with in Burlington with any great frequency, fewer than 1 a week. And I think that, maybe in that case, these kinds of things are a headache for the officer or for the person who's the victim, but they're relatively small and not cumulative. It has been a completely different landscape over the past 2.5 years.
It hasn't been the problem that's risen to this level. Yeah.
Gotcha. So what spiked it?
What spiked it?
Yeah.
I think that it is a combination of despair, increased substance use disorder, lack of consequence because of the clerk closure, and a lack of immediate impact because fewer officers available to make arrests. We were not taking stolen. I mean, a stolen vehicle is still a priority 3 under our priority response plan. So if I have 5 officers on a shift, and actually some of my shifts only have 4, and that's 4 for 16 square miles and 45,000 people, plus another 25,000 of daily incoming. Those 4
You
officers
said you had 4 officers
on the day shift.
size of Burlington.
And so what we have is something we don't like, which is a priority response plan, which is any call that comes in gets answered until we only have 2. So a retail theft comes in and the officer goes to that retail theft. A domestic violence comes in that has a 2-officer response. You've got to send 2. They go. This guy isn't going to anything until one of these people is free again. And then they'll go to priority 1s only, robberies, other domestic violence, etc. Now, if one of these guys becomes free, now we're going to anything again. But as soon as this one goes to a stolen vehicle, then these 2 are waiting for something bigger. And if a stolen vehicle comes in, or a burglary in the past comes in, or another retail theft comes in, they say no. We're waiting to be available for gunfire.
Did you tell me your police department right now is running at half of what it was before?
Yes, that is 50% patrol resources. That's correct. For non-supervisory patrol, we are 50% what we were in 2019.
Because there were a lot of open positions.
We have a number of open positions, and we're working hard to fill them.
I heard like 1 recruit or something.
Yeah, we only have 1 for this coming academy class, which stinks. But my field training officers actually need the break. They're exhausted because we brought in 15 new police officers in 2023, which is the largest number we've ever done. We've never brought 15 in a single year.
And why can't you get law enforcement?
Cops, you mean, why can't we hire? Well, we did have a very successful hiring year in 23. Why are we down to 1 right now? Because unemployment is, 3.8%, because there are a lot of economic markers that make it challenging for jobs like ours, because I think we'll probably end up with a larger crop in August when people are finished with school. But we didn't used to have to plan on new college graduates or school graduates. We used to get people in all sorts of phases, but those are contributing factors. And then, it's certainly no secret that law enforcement has had a difficult couple of years. I think we are coming out of that. I really do. I certainly know that we're coming out of that in Burlington. I feel very optimistic about where we are in Burlington with regard to community support, and with regard to the potential to grow. But there are obstacles in our way still. But that's where all of us are as a state. Right? None of us feels quite the same as we did in take your pick in 2010 or 2019 or what have you. It's just been a really hard this decade is going to be a tough, the first half of the 2020s is going to be a history book decade.
It's refreshing to hear that you're optimistic about the future when you're wearing that uniform. It really is. It gives me some hope, because God knows we need law enforcement. I'm not saying throwing people in jail.
No.
But just having a presence on the streets, having a presence on the highways, whatever, which most of the time I don't like seeing you guys on the highway. But it makes a difference. So, and thanks for what you do.
Thank you.
Any other questions?
Did you get to finish what you were? I know we
Yeah, no, I did. Yeah.
Okay, all right.
I think I do.
Well, really appreciate you coming out, and we'll try to have you out more. Especially like the state.
Thank you. I certainly appreciate the opportunity, and thank you for all that you guys do. I'm very proud to live in a state with a truly citizen legislature. I think it matters. So,
Thank you. So, before we break, just real quick, I'll kind of give you a game.
Don't be a stranger.
Yeah, if you see things you want to weigh in on, let us know.
Yeah, I'll make sure I invite you.
Thank you.
We've been spreading the wealth. We've been spreading the wealth on different chiefs coming in. So,
Absolutely.
I mean, the biggest city in Vermont. Why would we wait this long to see you?
Because you usually don't want to hear from anybody from Chittenden County.
No, From law enforcement.
Okay, all right, well, there you go.
Thank you very much.
Thank you, Chief. Thank you.
What?
You're in Burlington.
Are we still live?
Yes, we are.
Oh, wait.
So here's my game plan, and if folks are fine with this, is I'm gonna try to work with Michelle, and if necessary, if Tim's available, I'm gonna combine these into one bill. It'll probably be 563, which everybody likes so much, and maybe they'll forget that they don't like the other two parts, and they'll just say we like 563. You know what I mean? No, that's not gonna happen. So in any event, I'm gonna try to work.
I'm excited about the unanimous on
Yeah,
that.
they're pretty good. So
Yeah,
I'm going
really.
Keep
to,
it sacred.
Yeah, I thought it was gonna be the other one, everybody be unanimous on the trespass one.
well, the trespass, I mean, it's just getting it right.
Right, yeah.
And it's, the notice issue is really, I still think that's the main part of the issue. But it's the knowing standard versus a reckless standard versus a know or should have known. And that's the same exact thing with the operational consent. It's kind of like the same issue, and I'm going to try to get, what I might try to do is get language that would be along the recklessness, and then kind of language as this alternative that would be the criminal negligence standard. For then we can have a discussion. We can get some more testimony, but we can have a discussion among ourselves as well. Does that sound?
Yeah,
It's a
no,
joint bill.
no, that's great. No, I appreciate
Yeah.
it. So the notice part, I wouldn't, if I remember right, I wouldn't have to give somebody notice on my boat or camper.
I don't know about the boat and camper.
There was something mention of like
Right.
airplanes and.
Right.
But I would have to give them
That's-
notice for the car. That's the way I understood it. I may be wrong.
So
The only reason I'm pointing it out because that
If
makes
you're
no
worried about
sense.
your airplane.
That makes no sense.
Have somebody just go in your camper, motorhome, RV, bus, whatever you
Unauthorized-
want to say, and take over.
So.
All right, so wait, a person who, without the consent of the owner, takes, uses, operates, or removes, or causes to be taken, used, operated, or removed from a wharf, pier, anchorage, airfield, hangar, boathouse, or other building, or from any place or locality on a private or public enclosure or space, a boat, other waterborne craft, or aircraft used for the transportation of persons or property upon water or in the air. Who writes this stuff? And operates, drives, uses, or causes the same to be operated, driven, or used for his or her own profit, pleasure, use, or purpose shall be in prison not more than 1 year. Or
Let's just
fined
stick
not
car
more
in
than
there.
$500.
That's what I said, put on a
Who
automobile.
writes this stuff?
Be done.
Guys like
You know
you.
what? We also have more protections.
This
for
section, we're still
abandoned-
live. This section
airplanes
shall
and
not
boats.
be construed to limit or restrict prosecutions for grand larceny.
Yeah.
Say what? What was that?
I said, this section shall not be
For
construed
the
to
record,
limit or
I said it.
restrict.
15 minutes before you brought it up.
Yeah, what, just add car?
Yeah, you texted me. And I looked at it. It's,
That's.
I don't know, I read
Part of it just made a great point. Go ahead. I thought it was a great point.
Hey, that's good. Don't act surprised though.
What's that?
Don't act surprised, I did.
No, I'm just saying.
Yeah,
what you
yeah.
want.
So I said we have way more protection for abandoned airplanes and abandoned boats, and it does seem like it's.
Then we do somebody's
socioeconomic-
automobile.
Right, in terms of notification,
Helicopters.
recovery.
but see, I mean, that is what the operation without consent of owner is. It just because we have all of our car stuff in Title 23. So we threw in Title 13, the boat stuff. And that's, yeah, this is what we're after. That's along the
Right.
lines of what we're after, but
It must
just-
have been a problem at some point. A lot of boats and planes were getting messed with, and so.
Where?
yeah, I don't see when this.
Burlington. It's the only big lake.
Diplomacy, I don't know.
See, the thing is, if you look at a map of Vermont, and then this, we can ask Carolyn Brennan to give us the detail on this. There were more airports in this state than meets the eye.
Right,
Oh,
private,
We had 3 airports in Hartford.
and we still have a bunch, but they're for
Okay,
private
So,
planes.
you can almost understand why some of this stuff like came from where it came
You
from.
can walk onto an airport taxiway without any, like, I mean, it's state airport.
19
Any ID. you get in.
1949 is when the boats and the airplanes were put in.
See, and that kind of
What
fits,
was the airplane?
1949.
that kind of fits, the time,
Yeah.
the historic time here in the state.
Right.
If you really want to get